Morning. In this e-class, we'll discuss regarding institution of suit. Prior to our discussion regarding institution of suit, I should just make you remind or refresh your memory regarding this our previous discussion regarding place of suing. You are aware? Place of suing means the place where a suit is to be instituted. Who institutes the suit? Plaintiff has the suit. A suit is instituted by presenting a plaint in the competent court to try the suit. You are aware that every court has three types of jurisdiction. First is territorial jurisdiction, then second is pecuniary jurisdiction, third is jurisdiction as regards the subject matter of the dispute. So all these three requirements of law regarding jurisdiction must be complied before the suit is admitted. So you are aware of the provisions of section 15. What it speaks? Every suit shall be filed in the court of the lowest grade competent to try it. So in the lowest grade competent to try this suit, a suit is to be instituted. Never in a higher forum, never in a higher jurisdiction, because the reason is, if for the convenience of the parties, lower courts are established throughout the state. So it will be easier for the parties to approach the lower court first, because it will be convenient for both the parties and the witnesses to attend before the court for adjudication of a dispute. Besides, if a suit is filed in the higher court, then the higher courts will be overburdened with litigation. To avoid such things, the provision is made in section 15 that every suit shall be instituted in the lowest grade competent to try the suit. So far, suits may be filed in respect of immovable property, or in respect of movable property, or for compensation in case of tort. So all suits relating to immovable property is to be filed in the court which has territorial jurisdiction over that immovable property. Every court has territorial jurisdiction, within which territorial jurisdiction signifies the territories within which a court functions. So all suits regarding immovable property, that is to be instituted in the court which court has territorial jurisdiction over the property. Only in exception is that when there is wrong to immovable property, compensation is claimed for that wrong. In such case, the suit may be filed in the court within whose territorial jurisdiction that immovable property is situated, or where the defendant resides or voluntary carries his business. That is there. So that's why now suits for recovery of immovable property, for partition of immovable property, for foreclosure in respect of mortgage of immovable property, for redemption of immovable property, determination of either right or interest in respect to immovable property, compensation for wrong to immovable property, that suit must be filed in the court within whose local jurisdiction that immovable property is situated. So this is suit in respect of immovable property. So far as recovery of movable property, recovery of immovable property is within whose local jurisdiction the immovable property is situated. But only one thing, when a movable property is to recover, in such case, court within whose jurisdiction that movable property is there can be, suppose a truck, my truck has been detained by somebody at Bhubaneswar. So I have to institute a suit for recovery of possession of that movable property in the court of Bhubaneswar. Similarly, that compensation wrong to immovable property, that can be filed where the immovable property is situated or where the defendant resides or carries its business. So relief for this, where it is uncertain within whose jurisdiction of which two or more immovable properties are situated, then the court will adjudicate whether there is uncertainty or not. If immovable suit is to file in respect of immovable property which is situated within the territorial jurisdiction of two or more courts, then in such case suit may be filed within in the court, in any of the court having local jurisdiction in respect to any part of the immovable property, provided that suit must be within the pecuniary limits of that court. Similarly, compensation wrong to person, so far as movable property. So there, wrong to person means what? Suppose a person is defamed, or a person is assaulted, or a tortious act is committed. So compensation is claimed for wrong to person or wrong to movable property. In such case, the plaintiff has option. What is that? Either of the courts at the option of the plaintiff, where that the defendant is in, where the wrong took place. So this is in another suit where the cause of action, so far other suits are concerned, where the cause of action for filing the suit will arise. So, or the defendant resides. This is in nutshell regarding the place of suit. Now, what we mean by that, sometimes the plaintiff cannot file a suit according to his own choice. As per the provisions of the law provided in the Civil Procedure Code, he will file the suit within the court competent to try it. Forum shopping. What is forum shopping? Suppose a suit is to file within this jurisdiction in a particular court, and if it is filed in another court, that is never permitted. There is a forum, sometimes party for their convenience, a particular person, in order to harass another person, jumps a forum. He chooses a forum, chooses another court and files a suit. That court has no jurisdiction to entertain the suit, but if gives a relief, that decree or that decision is not tenable. The Honorable Supreme Court has disapproved strongly and also deprecated the practice and increase of tendency on the part of the litigants of crossing a forum which may oblige them by entertaining a suit or petition, though they have no jurisdiction in the matter. In one case, what is this registered office of a particular company was there in Punjab, but a petition was filed, a suit was filed in Calcutta High Court, and then an order was obtained. So because there the Honorable High Court of Calcutta lacks jurisdiction, so there it was deprecated. That is not permissible. You might have seen in some contract or in some placing some order for purchasing some articles through this online shopping, sometimes a clause is there, all cases are to be filed within the jurisdiction of the court of Delhi. Whether if suppose by knowingly or unknowingly you have signed that agreement or signed that, accepted the terms, can the defendant will compel you to file a suit in the court of Delhi? The answer is that, first, no. If Delhi court has no jurisdiction as per the provisions of the CPC, then such a suit is not maintainable. In a suit for compensation, where in case of breach of contract, where the contract is entered or where the defendant resides, so there is concurrent jurisdiction. If there is concurrent jurisdiction in respect of for filing a suit, then the parties by agreement, knowingly, by being aware of the fact that there is concurrent jurisdiction, they may exclude the jurisdiction one of the court. If you are aware, knowingly, you have entered an agreement excluding the jurisdiction of court of Bhubaneswar, then only then such a suit is to be filed in the court of Delhi. But if you are not aware that unilaterally the defendant cannot compel you to file a suit in a particular court. Only when concurrent jurisdiction is available in respect of the particular transaction or then, and the parties have mutually agreed, understanding the terms of the contract, then in such case, one of the jurisdiction one of the concurrent court may be excluded. So this is in nutshell regarding jurisdiction. So any doubt regarding this jurisdiction, you may send me through message or so that I will try to answer you. Now the institution of suit. How a suit is instituted? Suit is instituted. This section 26 of the Civil Procedure Code provides every suit shall be instituted by the presentation of plaint or in such other manner as may be prescribed. How a suit is instituted? Section 26. Every suit is instituted by presenting the plaint. What is plaint? Plaint has not been defined in the Civil Procedure Code, but the plaint is the memorandum, private memorandum of a party by which is filed before the court, through which he claims the relief in a matter, in dispute. In the plaint is the pleadings of the plaintiff. In nutshell, pleadings of the plaint is mentioned in the plaint. So, suit is to be filed, suit is instituted. How? By presenting a plaint. Where? By the presentation of a plaint. Who will present the plaint? Either the plaintiff himself will present the plaint, or the plaint may be presented through his advocate. Where it is to be presented? In the court. So every suit shall be instituted by the presenting a plaint or in such other manner as may be prescribed. Such other manner how? Different high courts have different rules how a plaint is to be presented. Some in certain cases they like so for a suit filed by an indigent person, that suit is to be plaint is to be presented personally to the presiding officer of the court. But in other cases, the plaint is presented before the chief ministerial officer of the court, that is the Shirastadar, usually in the state of Odisha. The plaint is presented to the chief ministerial officer, who is known as Shirastadar of the civil court, for that institution of the suit. So here, then, or in such other manner, if any other high court or any other state, there is a different rule that who will accept the plaint, in that manner, that is to be presented. Then, in every plaint, facts shall be proved by affidavit. This is in addition to the section in section 26 by way of amendment. But previously, no affidavit was required to be submitted along with or to file along with the plaint. Different high courts have different rules. Some high courts have prescribed that there should be affidavit supporting the allegations in the plaint. Now, by amending the provisions in section 26 of the Civil Procedure Code, there is uniformity uniform rule throughout India that in every plaint facts shall be proved by affidavit. How that proved is facts have to be proved? That must be supported by an affidavit. So you are aware how a suit is instituted. Suit is instituted as per the provision of section 26 of the Civil Procedure Code, that by presenting a plaint or on a such other manner as may be prescribed. So that means plaint is to be present. Where suit is to be filed, every suit is to simultaneously to be read with section 15 of the CPC, that every suit shall be instituted in the court lowest grade competent to try the suit. For an example, in the state of Odisha, the Civil Judge Junior Division has pecuniary jurisdiction to try suits up to 50,000 rupees. Suppose a person wants to, but the Civil Judge Senior Division has pecuniary jurisdiction to try suits exceeding 50,000 and upon limited amount. Suppose a person files a suit of suit valued at 40,000 in the court of Civil Judge Senior Division, that is not to be accepted, because every suit shall be instituted in the court lowest grade competent to try the same. So now, how a suit is instituted? Suit is instituted by presenting a plaint, where in the court or in such a manner as may be rule prescribed under the rules, and every plaint shall be proved. Every plaint shall be proved by an affidavit. This is section 26. Now, in this connection, now this is the suit institution of a suit. Now, in this connection, we should we should know the provisions of regarding institution of suit, that is, who are the parties to the suit, by how a plaint is to be prepared. All such rules are there in the order 1. In the order 1 of the Civil Procedure Code provides what it provides. Parties to suits. When a plaint is presented, there must be party. Or suit is instituted, there should be parties. Then who are to be parties to the suit? In every suit, there are two parties. One is plaintiff, the other is defendant. So who may be joined as plaintiff? This order 1, what it says, parties to suit, who may be joined as plaintiff. All persons may be joined in one suit as plaintiffs in two circumstances. All persons may be joined as plaintiff in a suit when any right to relief in respect of or arising out of right to relief in respect of arising out of the same act or transaction or series of transactions is alleged to exist in such persons, whether jointly, severally, in the alternative. Two requirements. All persons who have a right to relief, who are entitled a right of relief in a civil dispute arising out of the same act. Same act means, suppose three persons assaulted another. So the person who was assaulted, he can file a suit, that is in case of defendant. Suppose three persons are the owner of a particular piece of land. They were dispossessed by another. By same act, they were dispossessed. So all the three persons must join as plaintiff, because any right to relief, because all the three persons are jointly entitled for that relief. So any right to relief in respect of arising out of the same act or same transaction. All persons may be joined in a one suit. All persons may be joined as plaintiff in one suit when any right to relief they are entitled arise out of one act or series of acts or one transaction or series of transactions, whether they are entitled for that relief either jointly or severally or in alternative. And the second requirement is that if such persons brings a separate suit, if such persons brought separate suits, any common question of law or fact would arise. If such person will bring separate suits, there will be common question of fact and common question of law will arise. Suppose X had borrowed money from Y, Z and L. So he made default in payment of that money. So in such case, if X will file a suit against L for that money separately, Y will file a suit for the same money separately, claiming his share. Z files a suit separately against L for the money due to him. Then that will, in such suits, there will be a common question of law and fact will arise. Then who will be made as parties, as plaintiff in the suit? All persons will be made as plaintiff when they are entitled for relief either jointly, severally or alternatively, and because of a one transaction or one act, series of acts or series of transactions. And this must be read along with this, that if all of them will file separate suit, then a common question of law and fact will arise. So you should know who are to be made as plaintiff. If a single person, okay. If two or more persons, if a single person is entitled for relief, he will be made as a plaintiff. If two or more persons are entitled for relief, those two persons may be made as plaintiff. Or 3-4 persons are entitled for a relief out of a transaction, out of an act, they are to be, all those 3 persons are to be made as plaintiff. Now, second, power of court to order separate trials. Power of court to order separate trials. Suppose 3 persons as plaintiff filed a suit. Then it appears to the court, no, they are not entitled for joint relief. They are not entitled for severally, relief severally. Or the common question of law and fact is not involved in the case. So in such case, the court may direct for separate trial. What? Where it appears to the court that any joinder of plaintiffs may embarrass or delay the trial. It appears to the court that 2 or more persons have joined as plaintiff, that will delay or embarrass the trial of the suit. The court may put the plaintiffs to their election. Court may ask to elect or order separate trials or make such other orders as may be expedient. Expedient means necessary. So when it appears to the court, when the court will direct order separate trial. When it appears to the court from the plaintiff that the joint trial or the trial in the suit in respect of all the plaintiffs will cause embarrassment or delay the trial, or there will be delay the trial, then you will ask the plaintiff to elect whether you want to please file suit separately. Take your elect the plaintiff. What elect? Elect the plaintiff to their election. What type of election? They will withdraw the suit and file the suit separately. Election or order separate trial. If the plaintiffs do not elect, then the court may order there will be separate trial or make such other order as may be expedient, or the court may pass such order as necessary or as per, considering the facts and circumstances of the case. This order 1 rule 2 says. What it says? When the court will pass order for separate trial. What the provision? If it appears to the court that a plaint has been filed by 2 or more persons and court finds that separate trial is required to save delay or to prevent embarrassment. So in such case, the court will ask the plaintiffs to elect. What type of elect? To file separate suits. Or if they do not elect, or if the court thinks fit, pass such order as the court thinks fit, considering the facts and circumstances of the case. Now, who may be joined as defendants? First in order 1 rule 2, order 1 rule 1, order 1 rule 2 regarding plaintiffs. Who may be joined as plaintiffs? As you know, who are to be joined as plaintiffs? If all persons who are entitled for a common relief, they may be joined as plaintiffs. Similarly, who may be joined as defendants? Similarly, the provision, all persons may be joined in one suit as defendants. All persons may be joined as defendants in one suit. When any right to relief in respect of, that right to relief in respect of arising out of the same act or transaction or series of tract or is exist against such persons. They are in order 1, rule 1, in favor of such persons. The right to relief exists in favor of such persons or such of all the persons. Those persons are to be made as plaintiff. Similarly, right to relief exists against those persons. When all persons may be joined as defendants, when any right to relief arising out of one act, of series of acts, or one transaction, series of transactions exist against those persons, either similarly, jointly, severally, or in the alternative. Suppose, take an example that X has borrowed rupees 5 lakh from a particular bank. Y is the guarantor. Y is the guarantor. Suppose that X did not repay the loan amount. So here you are aware that the principal borrower and the guarantors, their liability joint and several. Jointly and severally means either the bank can realize that money jointly from those 2 persons or severally or separately from those 2 persons, either the principal borrower or the guarantor. So in such case, the right to relief is against the principal borrower and the guarantor is jointly or severally or even alternatively there. So in such case, those persons, all such persons will be impleaded as defendants. So here, similarly, again, if a separate suit is filed against such person, any common question of law or fact would arise. If the bank files separate suit against such persons, then a common question of law and fact will arise as per the example what I stated earlier. So in such case, who are to be made as plaintiff and who are to be made as defendants, you are aware. That means a person who is entitled to get relief out of one act or transaction is usually he is to be made as plaintiff. But when 2 or more persons are entitled for a common relief out of the same act or out of the same because of some transaction, then all those persons are to be impleaded as plaintiff. And the second requirement, that if they will file separate suit, then in that suit there will be common question of law and fact. So in such case, all such persons are to be made as plaintiffs. Similarly, who are to be made as defendants? All persons against whom a relief is to be, common relief is to be claimed, they are to be made as defendants. So the order provides all persons are to be made as to be defendants if any right to relief out of one act or series of acts, one transaction or series of transactions arise against those persons jointly, severally or alternatively, and if separate suits are filed against those persons, then by the plaintiff, then a common question of law and fact will arise. Now, then 3A, power to order separate trial where joinder of defendants may embrace or delay trial. Similarly, the court has the power to pass order for separate trial when there is this impleading of more than one plaintiffs, when that trial will cause embarrassment or delay. Similarly, when there is defendants of two or more than one defendants, in such case, when it appears to the court that any joinder of defendants may embrace, two persons would not have joined as defendants, but the plaintiff has joined them as defendants, and it appears to the court that if they will continue as defendants, then that will delay the trial of the suit, or it will cause embarrassment. Then the court may order separate trial. The court may order for separate trial or make such other order as may be expedient in the interest of justice. The similar principles, similar rules both for plaintiffs and for the defendants. So if a question is put to you, when the court will direct for that separate trials, power to court order for separate trials where joinder of defendants will embarrass the trial or will cause delay in trial. Similarly, the court will also direct for separate trial when the joinder of parties or plaintiff will embarrass the trial or will cause delay the trial. Now, defendants need not be interested in all the reliefs claimed. Defendants need not be interested in all the reliefs claimed. It shall not be necessary that every defendant shall be interested as to all the reliefs claimed in any suit against him. So it is not necessary that all the defendants, suppose two or more persons are made as defendants, it is not necessary that the same relief must be claimed against all the defendants. Common relief. So a different relief may be claimed against different relief. So that's this rule 3 says what? It shall not be necessary that every defendant shall be interested as to all the relief claimed in any suit against him. One relief may be claimed against one defendant, another relief may be against him, but the common relief will arise out of the same transaction or out of the same act. So, joinder of parties liable on some contract. The second section, rule 6 says, the plaintiff may at his option join as parties to the same suit or any of the persons severally or jointly and severally liable to any one contract, including parties to bill of exchange, hundies, promissory notes. That means when defendants are liable under the same contract, either jointly or severally, in such case, the plaintiff may at his option join as parties to the same suit all or any of the persons when they are severally or jointly and severally liable in any one contract. If in a contract, for an example, in all bank loans, there is guarantor and principal borrower. They enter a contract making them jointly and severally liable. So if jointly and severally liable means what? That means the bank has the option either to file a suit jointly against the principal borrower and the guarantor. Similarly, the bank has the option either to leave the principal borrower and to proceed against the guarantor for realization of the dues. It can do so. Similarly, the bank has an option either to file a suit against the principal borrower and leaving the guarantor. That bank can do so. So this provision is there in Order 1 Rule 6. What it says? The plaintiff may at his option. The option is there with the plaintiff. Join as parties to the suit. Same. All or any of the persons, or any of the person, one of the person, or all the persons who are jointly or severally liable out of a contract. Now, Rule 7. When plaintiff in doubt from whom redress is to be sought. Where the plaintiff is in doubt as to the person from whom he is entitled to obtain redress, he may join two or more defendants in order that the question as to which of the defendant is liable and what extent may be determined as between all parties. For an example, X had borrowed some money from a bank and he died, leaving his legal heirs. Legal heirs, 2 sons, 1 daughter. So in such case, suppose there is a dispute, there is a question, one issue is that one of the sons has been separated, was not living in the joint family. So in such case, whether that person is liable to joint family debt or not, so that is to be adjudicated. So in such case, what will do? The plaintiff is in doubt. When the plaintiff is in doubt, then as to the person whom is entitled to obtain redress, as to the person from whom entitled to obtain, he may join 2 or more defendants in order that the question as to which of the defendant is liable, he may implicate any of either them or a question of the defendant liable and to what extent may be determined as between all parties. Close this chapter, and in the next class we will discuss what is representative suit and what are the provisions in the Civil Procedure Code regarding representative suit. Thank you.